Welcome to The Explainer. I am absolutely thrilled you're here today because we're jumping straight into the high-stakes, behind-the-scenes mechanics of the Canadian justice system. We're looking past all that dense legal jargon to explore the raw power dynamics that literally shape the rules of our society. It's this fascinating, never-ending tug-of-war, and we're going to unpack exactly how it all works.
I want you to think about something for a second. What actually happens when the full, staggering power of the state, we're talking all its resources, the police forces, the prosecutors, what happens when all of that is turned completely against you as an individual? It's a pretty overwhelming thought, isn't it? Suddenly that abstract idea of state power feels incredibly visceral and deeply personal.
To answer that, we're drawing directly from the academic foundations of Canadian criminal law and procedure. And as we'll see from the experts, criminal procedure is so much more than just a dry, dusty set of static rules sitting in a textbook. It's a living, breathing history of exactly how we constrain or affirm the power of the state.
Now, the absolutely crucial concept here is jeopardy. When an individual is targeted by the justice system, they're placed in jeopardy. That means facing the very real risk of lawful intrusion into your privacy, prosecution, or even the ultimate deprivation of your personal liberty. Establishing the rules of jeopardy is really about managing massive, terrifying stakes. It's about drawing that delicate line between a secure society and your individual freedom.
Okay, let's dive into this. Here's our roadmap for the explainer today. First, the meaning of jeopardy. Then, the obstacle course versus the assembly line. After that, we'll look at the rise of victims' rights, the shrinking of defenses, and finally, wrap up with a field of conflicting values.
Starting with Section 2, Obstacle Course versus Assembly Line.
Now, what's really interesting here is how we have these two competing models of justice constantly wrestling for balance. On one side, you have crime control. Think of this as the assembly line. Its main goal, fast processing, getting guilty pleas, and protecting society. On the flip side, we have due process, the obstacle course. This model is all about prioritizing individual rights, leaning heavily on the Canadian Charter of Rights and Freedoms to enforce strict rules for police, like demanding warrants before they can search you. But here's the reality check. While the Charter definitely injected a strong dose of the obstacle course into the mix to protect our rights, the assembly line still totally dominates the day-to-day. The vast majority of cases still end rapidly in plea bargains.
And this brilliantly illustrates the ongoing dialogue between the Supreme Court and Parliament. And dialogue is a perfect word because it's not a strict hierarchy. It's a constant, back-and-forth negotiation. Take the defense of extreme intoxication. In 1994, the Supreme Court recognized the defense. A year later, Parliament, acting very much on that crime control model, pushed back and enacted Section 33.1 to restrict it. Fast forward, that law stood for decades until 2022, when the Supreme Court struck it down for violating charter rights. But did it end there? No way. Literally 5 weeks later, Parliament amended the law again to bridge the gap. It is a continuous high-stakes ping-pong match over exactly how justice gets administered.
Moving right along to our next section, the rise of victims' rights.
Historically, this whole battle was mostly a two-player game, the state versus the accused. But now, the rights of crime victims have entered the chat in a major way, and they generally fall into two very distinct camps. First, there's the punitive approach. This focuses heavily on deterrence and longer prison sentences to protect victims. Think about things like banning the purchase of sex to protect exploited persons, or really strict rules against claiming provocation. Alternatively, you have the non-punitive approach, which leans into restorative justice. The goal here is repairing social harm and addressing the root causes of why someone offended in the first place, using tools like Glatter reports for Indigenous offenders or community mediation. So both models are trying to support victims, but they pull the justice system in radically different directions.
We see this tension perfectly encapsulated in highly debated, politically charged topics like assisted suicide and sex work. Honestly, these issues act as the very rope in this tug-of-war. The courts will often strike down sweeping laws to protect an individual's personal liberty and constitutional rights. Then, in response, Parliament frequently drafts new, targeted legislation explicitly aimed at protecting the vulnerability of specific groups. Whether you personally view these new laws as essential, much-needed protections for victims, or as overreaches of state power, they perfectly demonstrate how the law acts as this neutral battleground for society's most conflicting values.
Which brings us to the next section, the shrinking of defenses.
When we actually look at the data and recent legal history, there is an overwhelming trend of that assembly line tightening its grip. Basically, successfully claiming a criminal defense is getting harder and harder. For instance, the defense of extreme intoxication? Exceedingly rare. The mental disorder defense? Still incredibly restrictive. Honestly, it's pretty much unchanged since the 19th century. Even defenses based on duress and necessity are tightly constrained by the courts now. The accused has to prove there was absolutely zero safe avenue of escape. Overall, this trend really aligns with rising punitive attitudes in our society. There's just a growing unwillingness to accept that serious criminal acts should be easily excused.
To give you a stark example of just how rapidly this can happen, let's look at the provocation defense. Historically, this could actually reduce a murder charge down to manslaughter if the accused was suddenly provoked. But in 2015, Parliament dramatically restricted this long-standing defense. Get this, it now requires that the deceased victim must have actually committed a major indictable offense against the accused, like a serious assault, to even trigger the defense in the first place. It's a surprising, pretty dramatic shift, and it clearly reflects a strong prioritization of punitive values and victims' rights over historical legal excuses.
Now for our final stop, a field of conflicting values. I absolutely love this quote from former Supreme Court Chief Justice Brian Dickson. He stated that the law lies in a field of conflicting values. This cements such a profound idea for us. All this tension, the debate, the constant back and forth between Parliament and the courts, those aren't flaws in the system. They are literally its foundation. We are constantly, endlessly, trying to balance the legitimate power of the state to keep us all safe against the fundamental, uncompromisable value of individual liberty.
So if there's one crucial point to take away from our explainer today, it's that the law is never finished. It is not some settled, dusty book on a shelf. It's a continuous, incredibly high-stakes negotiation. Every single time a new charter right is defined or a new piece of legislation is passed to protect victims, that delicate balance shifts. And it requires our ongoing attention, our scrutiny, and our participation. Because at the end of the day, those rules dictate the very nature of the society we all live in.
Which leaves me with one final provocative question for you to ponder as we wrap up. In this endless tug-of-war, when community safety and individual liberty inevitably collide, which model of justice do you personally value more? Do you lean towards the swift protective efficiency of the assembly line, or are you drawn to the rigorous individual safeguards of the obstacle course? Thank you so much for joining me for this explainer. Keep questioning, keep learning, and I'll see you next time.